So welcome to Jumbo IS and welcome to this lecture series called Prelims Powerplay 2026. Now before starting today's lecture, I want to address something, okay? This lecture series, if followed till your prelims examination, would serve you really well. It will help you revise everything in your UPSC syllabus, okay? Everything. You wouldn't have to study all these monthly magazines. You wouldn't have to revise from any other source. Just follow this lecture series and all your revision for UPSC Prelims 2026 will be covered comprehensively. Just follow it. Just give me 1 hour every day between 9 p.m. to 10 p.m. That's it. And from today till your prelims examination, you would have revised everything, properly revised everything. Okay? But to successfully, diligently, in a disciplined way follow this lecture series, you have to follow these golden 4 steps. Okay? If you will follow these golden 4 steps along with this lecture series, well, everything I just said with respect to revision of your entire syllabus would come true and you would definitely clear this exam and sit for your mains. Now, what are these golden 4 steps? Most of you already know, but I'm still going to repeat it, okay? You have to watch this lecture regularly at 9 p.m., then revise it and memorize it from the notes, okay? Then you have to ask your doubts. We have put you in our WhatsApp groups, ask your doubts from our teachers. And then give the tests on time. These are the golden 4 steps which every one of you have to follow if you want this lecture series to be useful to you. Okay, so do this. All right. Now for notes, for tests, for WhatsApp groups, well, you have to register for this. Okay, and the registration details are given in the comment section just below this video. So check that out. But in case there is any problem, a number is also given in the comment section. Just WhatsApp us on that number and we will help you out in every possible way. All right, let's begin today's discussion. Now, today's topic of discussion would be criminalization of politics. Okay, the thing is that there has been a lot that was said with respect to criminalization of politics. There are so many legal provisions, constitutional provisions, which prevent criminalization of politics. But recently, Government of India or the ruling party, Parliament basically, came out with a bill, constitutional amendment bill called 130th Constitutional Amendment Bill. Now, this bill is controversial, okay? Many criticisms are leveled against this bill, yet the supporters of this bill say that this would clean up the politics in our country, okay? So, in today's lecture, we are going to talk about 2 things. Number 1, the existing provisions in our legal system as well as our constitution which prevent criminalization of politics. But those provisions haven't worked properly. Therefore, the government thought that let's bring another amendment to the constitution which would further clean up our politics. Okay, so the first topic would be legal and existing provisions, existing legal provisions with respect to criminalization of politics, and the second would be 130th Constitutional Amendment Act. Bill, sorry, it's currently at bill stage. Okay, so let's begin today's discussion, okay, without further introduction, but do not forget these 4 golden steps. All right, let's begin. Criminalization of politics, Polity Lecture 7. As you all know, we are continuing with Polity, okay? Now, there have been so many reports which say that most ministers, a significant chunk of our ministers have criminal cases, significant, serious criminal cases against them. Many of our legislators, by that I mean MPs and MLAs, have serious criminal cases against them, right? Now, that being said, there are so many reforms that have been taken to prevent all of this. Okay, some constitutional amendments, some legal provisions, some laws that have been put in place to stop all of this, but this has not worked that well. Okay, and that is why the government thought of bringing this constitutional amendment bill. We'll talk about this constitutional amendment bill a little later. First, let's talk about the current situation. Okay, so as far as current situation is concerned, as far as today is concerned, there are so many legislators. In fact, many say that around 45% of the ministers in our country, that includes central ministers and state ministers, have criminal cases against them. Now, that is a serious issue. Plus, many MPs and MLAs have serious criminal charges against them. Now, why is this bad? Why does this harm our democracy? Well, the consequences of this thing is that it erodes, number 1, the consequences. Okay, what problems do we face because of this criminalization? It erodes public faith in democracy. People have this perception that most criminals will get to power. Therefore, they won't get justice, right? So it erodes the faith of people in democracy, that democracy serves them. Okay, this is one. Then there is a conflict of interest. lawmakers become lawbreakers, or lawmakers are those who are lawbreakers. If there are many legislators who have criminal cases against them, well, they won't bring in a law that stops them from committing these crimes. For example, if there is a criminal who earns a lot of money, black money, and well, washes it through money laundering, now that legislator will make sure that there is no serious law that prevents money laundering. You understand, there is this conflict of interest. So this is a problem. Lawmakers as lawbreakers. Then, if criminals are elected to power, well, that institutionalizes corruption. Okay? And these criminals bring in a lot of black money. And they bring that black money into electoral process. So our electoral processes, our elections are flushed with black money. So this is a problem. And many more problems exist. Clear? So these are the problems which most of you are aware of. Now let's talk about what are the existing legal provisions that prevent this criminalization of politics. Okay? What laws are in place that prevent this? Okay? So legal provisions. Now, the law that regulates elections in India is Representation of People's Act 1951. Clear? Now, as per Section 8 of Representation of People's Act, if there is a politician, a MP or MLA, against whom a case is being filed, against whom hearing or against whom there are serious charges, and he is convicted of those charges, he or she, if a legislator, a politician is convicted of those charges, okay, and the offense that he has committed is serious, the offense that this person has committed has minimum of 2 years of imprisonment. Okay, if that is the case, then that person shall be disqualified for 6 years, disqualified from fighting elections. So if there is a person, politician, against whom there was a case and he was convicted in that case, and the case had a punishment of more than 2 years, well, under Section 8, he shall be disqualified for 6 years. Clear? By the way, you should be aware of Section 11. Section 11 says that Election Commission of India can reduce this 6-year disqualification period or increase it. The power lies with Election Commission of India to tweak with the time period of this disqualification period. Okay, this Section 11 is criticized by many, but nonetheless, we have this. Clear? Now, there are many laws, okay, many laws, many criminal offenses under which many MPs or MLAs have cases, okay, and they would be disqualified as per Section 8. But this thing is not working properly, okay, because despite this Section 8 of Representation of People's Act, there are still many politicians who have criminal cases against them, right? So to stop that, I mean, that was the idea. Well, the government introduced 130th Constitutional Amendment Bill. Remember, this bill is still at bill stage. It has not become an act. But still, it is very important to understand this bill. Make sense? Clear? So 130th Constitutional Amendment Bill was introduced to basically plug the loopholes within the existing system. Make sense? Right? Because the system is still not working, that is why this bill was introduced. All right. Now, this is what the law says. Currently, this is what the law says with respect to stopping criminalization of politics. Has judiciary passed some judgments which tried to prevent criminals from getting elected? Yes. There are various landmark cases under which judiciary tried to stop criminalization of politics. Okay. So some of those landmark judgments are important for you to know because questions can be asked. So important judgments in this regard. So number one is Association of Democratic Reforms versus Union of India 2002. Under this, Supreme Court said that when any politician files for the nomination process for elections, he has to file an affidavit. He or she has to file an affidavit. And in that affidavit, he has to furnish all the details with respect to criminal cases against him. Okay. So this was made mandatory within the nomination process. All politicians have to reveal in an affidavit while filing for their nomination all criminal cases that are pending against them. This was done by Supreme Court of India, and this was done so that there is transparency in electoral process. Okay, so that people also get to know about the criminal charges against these people who are fighting for elections, against these people for whom they might vote. Okay, so this was very important case. Then The most important among them, the most important judgment was Lily Thomas versus Union of India. And let me spend a little bit time explaining what Lily Thomas versus Union of India was. Okay, you remember section 8, we just talked about this. Under this, if a politician is convicted for an offense for which minimum punishment is 2 years, he gets disqualified for 6 years. Right? Now, you know what used to happen? Suppose there is a politician and in the district court, there is a case against him. Okay? In that district court, he is convicted of that offense. Okay? So the district court finds him guilty. Right? Now he should be disqualified for 6 years as per section 8. But what did that politician do? That politician used to appeal against the judgment of district court in the high court. If the high court also rules against him, well, then he used to appeal against that judgment in the Supreme Court. Now, because he used to appeal in the high court, he used to say that, look, the case is still going on. Okay, I am convicted in lower court, but the case is still going on. So I'm not finally convicted. Therefore, this disqualification doesn't apply to me. You understand? District court found that person guilty. He should be disqualified, but he appealed against that judgment, saying that the case is still going on. So this disqualification did not apply. And you know about our judiciary. Cases go on and on for so long, right? 10 years, 20 years. And for those 10, 20 years, that politician used to go scot-free. Okay, this disqualification did not kick in, right? This was a problem. No politician was disqualified under Section 8 because he used to appeal against that judgment. So to stop all of this, in Lily Thomas versus Union of India, well, the court said that if you are convicted in the lower court, you will be disqualified even if you appeal in the high court. Your disqualification will end if the high court finds you innocent or if the Supreme Court finds you innocent. But till that time, you shall be disqualified to fight elections. So this was a landmark judgment, and because of which many politicians got disqualified. Many famous politicians got disqualified. Okay, so this was a very landmark judgment. Clear? And then another important judgment, Public Interest Foundation versus Union of India 2019. This basically mandated all political parties to reveal criminal cases against their members on their website, on social media, everywhere, so that there is more transparency. All political parties should file or should publish criminal cases against their politicians on their website and social media. So this was there. So these are some of the important judgments. So this is the current situation. But the current situation was also not, well, to put it mildly, not solve the problem. Okay, the current situation could not solve the problem completely. There is still a lot of criminalization. And to stop all of this, well, the government said that we need to amend the constitution. And for that, they passed, or they introduced, because it has not been passed yet. It has not passed yet. 130th Constitutional Amendment Bill. Okay. Now, let's discuss the provisions of this 130th Constitutional Amendment Bill, because only then you will understand why this is being criticized. It is trying to do something noble to stop criminalization, yet its provisions say a different story. Okay, and there is scope for political misuse also. So let's discuss the provisions of 130th Constitutional Amendment Bill. Okay, so what does this bill say? So this bill basically allows removal of PM, Chief Minister, or any other minister in union or state, okay, who is held in custody for 30 consecutive days for a serious offense for which the punishment is 5 years or more. So if there is a politician, if there is a minister, by the way, we are talking about ministers. If there is a minister against whom a case was filed, okay, and CBI or ED detains him, and the detention is for more than 30 days, 30 consecutive days, he is unable to file bail, okay, then on the 31st day, he shall be disqualified. Clear? This provision applies to Prime Minister, applies to Chief Ministers of all states, applies to Chief Ministers and Ministers of Delhi and other ministers as well. Clear? You understand? So if you're not found guilty, okay, there are just allegations, but based on these allegations, CBI and ED have detained you for 30 days. The case is still going on in the court, but they have just detained you. So if the detention period is more than 30 days, you are disqualified. Okay. Now, to do this, you have to amend Article 75 of the Constitution, which is related to union ministers. Okay. Article 164 of the Constitution, which is related to state ministers, CM and other ministers. And Article 239 AA, which deals with ministers in Delhi. Okay, ministers in Delhi. Clear? So 130th Constitutional Amendment Act bill applies to union, states and Delhi. But we want it to extend to those union territories which also have ministers like Puducherry and J&K. Okay? So to implement these provisions in Puducherry and J&K, well, there are separate laws that are being brought in. Okay, for Puducherry, it is, well, Union Territories Bill. Okay, for J&K Reorganization Bill. Clear? So there are three bills. 130th Constitutional Amendment Bill, which deals with Union State Delhi. Another bill which deals with Puducherry. Another bill which deals with J&K. But their provisions are same. PM, CM, any other minister can be removed if this is done. Clear? Currently, this bill is pretty controversial, and I'll tell you why it is controversial. Okay, this is very controversial, and that is why this bill has been referred to Joint Parliamentary Committee for analysis. Clear? Now let's talk about these provisions in detail. Okay, so what happens? So key provisions. Okay, what are the grounds for removal? How can you be removed? So any minister arrested and detained in custody for 30 consecutive days. Remember, consecutive days. For offence with 5 or more years of imprisonment, well, that person shall be removed. Okay, now remember this. I'll give you an example. Let's suppose ED or CBI files a case against the former, he's former now. Let's suppose he files a case against MK Stalin. Okay, ED files a case against MK Stalin. Okay, the Chief Minister of Tamil Nadu. And well, as per that case, he is detained for 30 days for questioning. The charges against him are not proved yet. He might be innocent, but he is detained for 30 days. If he is detained for 30 days for questioning and he cannot get a bail from the court, well, he'll be disqualified. You understand now? Okay? And this is the problem. Because many people allege that ED or CBI, many people allege, that is not the case, or maybe it's the case, but many people say that ED and CBI are misused by the union government. So union government can use ED or CBI to disqualify opposition party members in different states. You understand? That's the controversial bit. Nonetheless, for union and Delhi ministers, for normal ministers, not prime minister or chief minister, well, other ministers shall be removed by president on advice of PM. When we are talking about union ministers, in case of Delhi, they shall be removed by president on the advice of Delhi CM. But if the prime minister or Delhi chief minister does not give that advice, then on the 31st day, that minister shall be automatically removed. Okay? Then what about prime minister or chief minister? Well, if the prime minister itself or the chief minister of any state is detained for 30 days, well, he or she has to hand in their resignation on the 31st day. If they don't, they are automatically removed. Okay, for other ministers, the advice to president is mandatory. For prime minister and chief minister, okay, they shall be removed. By the way, for other state ministers, the chief minister shall give the advice to the governor and governor shall remove them. But if the chief minister itself is detained for 30 days, he has to resign or he'll be removed automatically on the 31st day. Okay, so for union ministers and Delhi, president. For state ministers, it's governor. And the advice should be tendered by chief minister. By the way, there is no bar on reappointment. After they are released, they can be appointed. Okay, when they are released from custody. So this is the thing. All right. Now, well, what are the benefits of this bill? The benefits are usual. It will stop criminalization of politics, blah, blah, blah. Many other benefits are there, which you already know. Okay. But there are some criticisms and you should be aware of those criticisms. Okay. So what are these criticisms? So first of all, whoever is in power at center, okay, can misuse it. And this political misuse can be a threat to federalism. okay, the ruling party at the center can use this provision and ED and CBI for political vendetta or to basically disqualify opposition ministers in states. So this is one problem, and that is why there is such a hue and cry about this bill. Clear? Because many opposition parties say that this bill is designed to persecute opposition ministers in states. It is designed to do this. It is designed to be misused. Clear? Then it is against principles of natural justice. How is it against the principles of natural justice? Well, one principle of natural justice says that you are innocent until proven guilty. So until you are proven guilty by any court of law, you are innocent, you are presumed innocent. But not in this case. Okay, in this case, you are not found guilty. Just on the mere fact that you have been held, detained for questioning for 30 days, you shall be disqualified. Now, you are not presumed innocent. That is why you are, well, disqualified. So this is a huge problem against principles of natural justice. Then, lack of parity between ministers and MPs, MLAs. Remember section 8. Well, all the other MPs and MLAs, they would be disqualified under section 8. Under section 8, this principle of natural justice is taken into account. You have to be convicted by a court to be disqualified under section 8. But for ministers, as per 130th Constitutional Amendment Act, well, this principle is not allowed, okay, or is not followed. So there is no parity. If there are serious criminal, let's suppose there is an MLA, okay, he's detained for 30 days or more, he won't be disqualified. But if it's a minister, that minister will be disqualified. Because the MLA would be disqualified under section 8, but the minister would be disqualified under this bill. So this is a problem. Then there is a lack of legal safeguards as well. Well, the biggest legal safeguard is principle of natural justice, okay, which is present in section 8. Clear? So there are chances of misuse and political instability, because every party that comes to power at the center will use this bill to remove chief ministers or other ministers of opposition ruled states. And these people would get disqualified. Then when they'll be found innocent, they will come back, then disqualified, then come back. Don't you think all of this would create a, well, political instability? This would create political instability. So this is another criticism. And that is why there was such a hue and cry in the parliament. That is why it has been referred to Joint Parliamentary Committee. Make sense? Right? Now, what is the way forward? Way forward to reduce criminalization of politics. Now, look, way forward is important for your mains examination because you have to write way forward in your answers. It's not that important for prelims examination. Nonetheless, I have mentioned some suggestions, way forwards, in your notes. So go through that, like 244th Law Commission report, okay, and many other way forwards exist, which can basically go a long way in reducing criminalization of politics. But let me warn you in advance, this is important more from the perspective of mains rather than prelims. So don't spend too much time on it. Clear? And by the way, do not forget to save and revise this lecture from the mind maps and notes. Revise the notes, memorize the notes, then save the mind maps that I share with you. Okay? Those mind maps are important for quick revision during the end days of your preparation. Okay? So save those mind maps. All right? And that would be all. With that, we conclude today's session. I'm sure this session has added value to your preparation, but the true value would come out if you are consistent and regular with this lecture series. You watch this lecture every day at 9 p.m., then revise and memorize from the notes, then ask your doubts in the WhatsApp groups, and then give the test on time. This is very important. To register, well, I've mentioned this. The details are given in the comment section below. Okay. On that note, I'll be signing off with the promise of seeing you with another topic in this Prelims Power Play lecture series. Thank you, everyone.